So I think we're going to begin. Sorry about the confusion with the room change. It looks like this room is going to be our classroom from this point onward. At least Wednesday, we're also scheduled to be in here, and this was the room that we're supposed to be in the entire semester. I have a few extra copies of the syllabus for those who might not have been here the other day. And again, this is all going to be on course space as well, and you can access the materials there. So I just returned from a wonderful trip to my reserve. We were home there for 4 days, and it was with Osgoode Hall Law students. It was the Anishinaabe Law Camp. And so we started Thursday evening, went all day Friday, Saturday, Sunday morning. I flew in last night about 12:30 in the morning. But it was a great experience to be able to be on the land and to identify for the students there in context where all the sources of law could be located by looking at the trees, the rocks, the water, listening to the winds. I mean, I know that sounds very strange in a law class where we're used to case books and looking at legislation, but when we're in that site and it's mediated by elders and there's an opportunity to talk about the language, it really, I think, did facilitate another layer of understanding to what it means to not just learn Anishinaabe law or Indigenous law, but also to practice that law. The students had an opportunity over the weekend to be able to do that. I know in a couple of weeks here at the University of Victoria there will be an Aboriginal camp, and some of you might have already attended that in past years. It's something that I would encourage you to take advantage of again this year if there's space. I'm not sure how they're signing up, but the 4 communities that are closer to here will be participating in the event this year. So today we're going to be talking about the Indian Act. We're continuing our theme of looking at governance. And last class, as you know, we looked at more traditions of governance. We had a discussion of the origin stories of many Indigenous communities. We talked about how those origin stories then developed into relational paradigms with First Nation to First Nation dealings. Then from that, we looked at the arrival of Europeans and how governance was continued to be constructed on a relational paradigm. Following that, it became a little bit more formalized through the treaty process. And then finally, we saw something called the Royal Proclamation of 1763 and the Treaty of Niagara of 1764, which was commented on positively in the Chippewa-Sarnia case to recognize that First Nations people in Canada, Indigenous peoples in Canada, have their own governance systems that were recognized upon contact, and that the Crown itself relied upon the cooperation of Indigenous peoples in order to ensure that they could develop their own infrastructure of governance and trade and settlement in North America, and now what's become Canada. So we're going to continue to follow that theme as we look at traditional governance and some of the challenges to traditional governance that have been faced. And so a bit of the lecture themes are just found here on the board today. We're going to be looking at a Haudenosaunee example of governance as talked about in the materials. And then following that, we're going to be looking at challenges to these traditions primarily through the Indian Act lens and see what the Indian Act has done to transform those other ways of relating to the world. And then finally, we're going to look at Section 35(1) of the Constitution to see what it is doing in relationship to governance. So the lecture comes in 3 parts today. Tradition, the Indian Act beginning to erode tradition, and then Section 35 and the hope and possibilities that it might be able to restore some of those earlier types of relationships. So we begin with the Haudenosaunee Confederacy. This confederacy is found by and large south of the Great Lakes. Here you see Lake Ontario, and you see the people's nations gathered across the area from the Hudson River over to Lake Erie itself. The Haudenosaunee people were originally a group of 5 nations, and so as you move from east to west, you've got the Mohawk, and then the Oneida, then the Onondaga, over to the Cayuga, and eventually to the Seneca. They were joined by a 6th nation in the 1720s, I believe, the Tuscarora people, who came up from the Carolinas because of the challenges that they've been having as settlement started to impact on their traditional territories. So today we call the Haudenosaunee Confederacy the Six Nations. They are an Iroquoian-speaking people. And the story in the materials talks a little bit about how this confederacy was formed. What you've got here on the eastern side with the Mohawk is what they call the eastern door of their confederacy. They view their laying out across the land as being like formed into a traditional longhouse. The longhouse were the structures that they lived in, obviously, prior to the arrival of Europeans and for a good time afterwards. And so they call themselves the people of the longhouse, one, because of their dwelling, but 2, because of their political structure, which again, the Mohawk guard that eastern door. In the center you have the Onondaga people who are guarding the fire, and in the western door are the Seneca people. The story, the origin story of this people is quite extended to be able to recount. If you wanted to listen to the Haudenosaunee constitutional recitation, it takes 7 days to be able to recite in the people's language. And they do that every year. Jake Thomas, who I met when I was a young law professor, used to be a part of this gathering. And through that 7-day period, they recount their preamble, they identify the structure of governance, they talk about the process by which governance would be maintained. They have lots of cases that are present in the narrative, as there's interpretive tools through telling stories about structures of governance, obligation, legal process, decision-making, etc. The basic outline of this, I'm not Haudenosaunee, is that there was a time when these people were in great war with one another. A huge war raged across the land, and no one could feel settled or comfortable or really enjoy much of a civic order. There was a threat that was always constant in their place. And in this time was born someone in the Wendat nation, or the Huron nation, which is on the northern parts of Lake Ontario. Yesterday we talked about, or not yesterday, the last class, we talked about the Wendat, or the Huron people living between Collingwood, what's now Collingwood, Aurelia, and Barrie, and there was about 40,000 Wendat people that lived there. Well, there was a man of the Wendat nation who was born in this time of conflict that was taking place throughout the Iroquoian-speaking nations, and he had a message of peace. And in his message of peace, he was rejected by his own people. And so he came down to the Great Lakes and built a stone canoe. And with that stone canoe, I think it was a white stone canoe, he sailed across Lake Ontario and found himself in Mohawk territory on the eastern door of the Confederacy. And in that place, with that conflict, he started putting forward this message of peace that he had tried to give to his own people. And it was a difficult message to be able to receive, and he was rebuffed, rejected by most that he proclaimed it to. But eventually there was a woman of the Mohawk nation, Jigonsase, who accepted the message and changed her way of orienting herself to the world, saw that in the law that the peacemaker was expressing, that there would be a better path to civic peace. And so, given the fact that this woman became the one to accept the first message of peace, in the Haudenosaunee Confederacy, governance is a matriarchal phenomenon, a matrilineal phenomenon. There are what's called clan mothers. Clan mothers choose who is going to be the political leadership in the community by identifying who they see is growing up in a good way, following kinds of ideas like the peacemaker was outlining this idea of peace and friendship and respect. Peace, power, and righteousness is the words that they actually use in their own Confederacy story. And so with Gigantase as an ally, the peacemaker continues to travel throughout the Mohawk territory, and he meets a person called Hiawatha. And Hiawatha of the Mohawk Nation at first rejects his message, is not very amenable to it. But there's a part of the story where the peacemaker is up on a roof, looking over, spying on Hiawatha one day as Hiawatha is boiling all of these things in a pot, and Hiawatha sees the reflection of the peacemaker in the pot, who's spying down through the hole in the big house, and is sort of taken by the persistence and the perseverance and the message that the peacemaker has. So he starts to follow this path of peace. And so the peacemaker and Hiawatha begin traveling amongst the Mohawk people more generally. There's a lot of back and forth, but there's eventually an acceptance of the great law that is being proclaimed. With that acceptance by the Mohawk Nation, there's this further journeying. Eventually, Hiawatha, the peacemaker, find themselves in the central part of the Confederacy in the Onondaga Nation, which is in the Finger Lakes area of New York State. If you ever go to Cornell University or something, that's the heart of Onondaga territory. And there meets Tadadaho, who is a really twisted, evil, trickster-like character who rebuffs the message of peace. And so again, the peacemaker, the Hiawatha, continue to travel along in their journeys, and eventually, through a series of challenges and a series of great feats, there's a widening of respect that occurs in the other nations, the Oneida, the Cayuga, the Seneca, for following this path, but there's still this holdout by the Onondaga Nation. And then there's a set of negotiations between Hiawatha, the peacemaker, and Tadadaho with the Onondaga Nation. He finally agrees to join if the Onondaga people can have a central role in this peacemaking function. And so with that agreement, the Confederacy, the Longhouse, is formed. And there's an image here on the one side of what they formed, which is called the Great White Roots of Peace. They decided to bury their weapons of war under this tree, and this tree would spread out and cover them and shelter them and guide them. They have an eagle on the top that watches over the affairs of the council. And this Great White Roots of Peace, this image was meant to not just cover the 5 nations originally, and eventually the 6 nations, but others could join this league or become allies to this league, so that what you get here is a confederal structure. Before the United States was formed as a confederation, and later a union, or before Canada was formed as a confederation, there was this example of federation just in the heart of what was growing in colonial America. The colonists, they encountered this kind of form of government. Another part of this image here is you see with the, this was a wampum belt. It's reproduced just here as a sketch. But you've got the Mohawk, Oneida, Onondaga, Cayuga, and Seneca laid out in this fashion. You can see a bit of the wampum pattern there. Look how the central image of the white roots of peace on this way looks like a tree, but then when you turn it over, it's meant to represent a heart. So there's one of the images that people are drawing their hearts together in peace and friendship and respect. And then along the middle of this wampum belt, there's a road so that you can travel unobstructed between the nations from the east and west of the Longhouse through the door. Whenever a decision was made, the Mohawks would take the matter first, and they would talk about it amongst their, maybe they had, I'm not getting the right numbers here, but say they had like 12 different clan chiefs, those 12 different clan chiefs, would talk about a matter and through deliberation try to come up with how the Confederacy might deal with that. They would then pass it across to the Oneida, and there would be a further development of some kind of consensus. Then it would go to the western door, and the Seneca would take the matter that they'd received from over here, and then they would introduce the Cayuga into the discussion. So they would pass the matter across the fire, further deliberation would come here, and then if there was consensus between that group, they would then pass it to the Onondaga, the fire keepers, and if there was an agreement, it would become the law of the Confederacy. If the Onondagas found something that wasn't quite appropriate with it, it would be sent back out for further committee study, right? Basically, you've got a system of checks and balances that is happening in this form of government, a system of deliberation to ensure that across the territory you don't get the type of war that was occurring in the earlier framing. The tradition is something that allowed them to be able to extend a lot of their influence not only across that northern part of colonial America and Canada, but they also found that they had great influence throughout the Ohio Valley because of the strength, and even up into the Lake of the Woods area for a while as they extended their influence. So they had ways of memorizing how this business would become pushed across. This is called a condolence cane. On the top of the cane you have these different pegs that are put in place representing the nations that were talked about. So there, is a memory device as you're trying to come to decisions. Each of these pegs would represent a named chief. Again, the clan mothers would be appointing these chiefs, and they would remove these chiefs if they didn't follow the ways of their particular nations. There's also something called a circle wampum, doesn't reproduce here very well, where instead of having these rows, you put them into a round circle, and then the strings all attached together in the center, almost like a wheel. If you can picture a wheel, the idea is that they're joined together in the different directions, and that's a constitution, right? It has now been written in English, and so you can read about all these different clauses and what the responsibilities of the chiefs and member nations are. But it gives you a sense of a founding, and through that founding narrative, an ability to be able to go back and work out challenges and problems through time. So with that background, you have the development of a quite significant model for not only their own nations, but for other nations that are indigenous that surround them. And then, of course, they find this, they also provide a little bit of inspiration for the colonial governments as well. So this hundreds and hundreds of year-old confederacy eventually met with what we were talking about last class, with settlement. And in the 1830s, most of the governance decisions that the Crown wanted to work with First Nations on were undertaken by the military arm of the Crown. Remember the last class, the First Nations were often a threat to the settlers, or at least could hold their own and influence the affairs of how things were developing in North America. But following the War of 1812, when the First Nations could no longer play the English off against the Americans, before they played the French off against the English, they started to lose some of their influence. And so eventually, in 1830, the Crown, when they deal with Indians, move away from dealing with them as a military issue, and they put this in the hands of a civil authority. And with this civil authority, eventually in 1850, when you have the Canadas together, you get the passage of something called the Act for the Gradual Enfranchisement of Indians, the Better Management of Indian Affairs is the name of the first piece of legislation. Eventually, it changes its name again, 1857, the act to encourage the gradual civilization of Indian tribes in this province and to amend the laws relating to Indians, Fifth Parliament of the Province of Canada. Remember before we talked about the two-row wampum belt and the linking arms together, and that one, that is the Crown, wasn't to interfere in First Nations affairs, First Nations weren't to interfere with Crown's affairs. You start to see in the 1850 and 57 legislation, after 200 and some odd years of encounter between the groups there, this stepping into the other's canoe, or stepping into the other's ship of state. And in 1869, this is further extended after Confederation, basically consolidating what took place prior to Confederation. And then in 1876 is the passage of the Indian Act. The Indian Act is meant to civilize, in quotes, assimilate Indian peoples. It's meant to control so much of their affairs and all parts of the way that they live within their communities. And you get this act basically being extended down to the present day. There's a few amendments in the 1920s which are hostile to Indians. There's a few amendments in 1951 that are a little bit more helpful to Indians. There's been a few amendments in the last couple of years, but I say very few. Basically, how Indians are expected to be governed on reserves today is in accordance with this 1876 piece of legislation. That's the baseline. Right? So there's now a conflict developing in this intersocietal story that we talked about last class, where Indigenous peoples with their own traditions control their own affairs, and the Crown, through imperial law, is trying to control its own affairs. And for a while, there was a healthy mingling, as we saw in the Conley and Woolrich case, where Indigenous law could be part of the law of the country and given force through the doctrine of continuity. Now we see a very explicit idea of getting rid of Indians by creating a schoolhouse, basically through the Indian Act, to introduce them to Victorian values and Victorian ways of living, so that the reserves was hoped Indians were regarded as a dying race. They would eventually just continue to decline in numbers. Those few that were left would go through this Indian Act system, learn how to be like those around them, be sent off to residential schools, and the idea is, in a future day like today, there would be no more Indian issue. Well, for the Indigenous peoples, they didn't take this kindly. They didn't take this as something that they saw as in their interest and the way they wanted to proceed in the world. And so you see on page 37 of the materials, if you've got the casebook or you can look at it later, there's an objection by the Six Nations people to the implementation of this Indian Act. And they refer to the Crown, the King, as our honorable brother by treaty of peace, but we want to give you notice that a very great hindrance and grievance in our council is starting to develop, because we believe that the spirit of those two-row wampum, linking arms together kind of affairs that we talked about last class is being violated. And they ask that that grievance be removed. In other words, that the Indian Act be removed. Do not try to enfranchise us. Do not try to change our traditional ways of governance. Do not try to change the way that we hold lands. Remove this from us. Remove this idea that says we are subjects to the British government and ought to be controlled under those laws which was passed in the Dominion Parliament by your government. Remove the Indian Act, right? Right on the heels of its passage, there's an immediate objection there. You'll remember the image that we talked about last class, which is the linking arms together image. They see what's going on here as being contrary to that way of living. This is what the Haudenosaunee agreed with the United States government. Here you've got the nations linking their arms together. So if help was needed on the one side, you would just pull an arm, and the person would come to your aid on that side. Likewise, If the government needed help, you would pull the arm and the Indians would come to the aid of the government. Well, in the middle here of this belt, you might not be able to see it that far back, but there's just under my chin, there's a house there. This is called the George Washington Belt, because south of the border, what they did when they wanted to preserve their Confederacy is say, we will not be your subjects, we will be your allies, we will be your brothers, we will be your friends, but we will not be subordinate to you. And you can see in this image here, there's not an image of subordination, but of equality, of ally, of friendship. And this is what the First Nations, the Six Nations in Canada also wanted to experience with the Crown, and they felt that they had received that kind of a promise as well. And I can just pass this around for you to look at a bit more closely. But with this promise, the government didn't respond when they made that kind of objection to the passage of the Indian Act. And so what you have in the materials next is the consequence of this. Got this Indian Act being passed, again, trying to change traditional government, trying to change the way that people relate to their territories. And these kinds of exclusions just start snowballing in Canadian law. These are hardwired in judgments, hardwired in legislation. You add to that the limited political participation that the First Nations have in the Canadian state from the time of Confederation forward. So for instance, I think the material talks about here in British Columbia, at the time that the province was formed, there might have been something like 40,000 Indigenous peoples. I'm not sure of the exact numbers, I did know at one point, but maybe 10,000 so-called white. And then there was a good number of people who are of Japanese and Chinese origin as well. One of the first acts of the colonial legislature of British Columbia was to pass a law setting the franchise, and the franchise was only extended to those who so-called identify themselves as whites. So you get a majority of the people from the get-go not having the right, the ability to be able to elect anyone into the Parliament, the legislature here, but also to elect anyone to Parliament, because often the federal franchise was calibrated by the provincial franchise. And so if you wanted to do something about the problems you felt were going on in London or Ottawa, you didn't have the ability to go to the ballot box. And for some people, like the Haudenosaunee, that's fine. They don't want to participate in those structures. But for some, like First Nations up and down the coast here, they feel aggrieved that they're not able to have a voice in how policy is being set in Victoria and in Ottawa or London. Added to that, there is an outlining of the religious freedoms that people have throughout their territories in Canada. The Indian Act was amended, for instance, to make it illegal to be able to engage in feasting structures, which were part of the governance systems here up and down the coast, where you would gather with named chiefs, with button blankets, who would talk about their territory, would transact business around marriage or trade or other kinds of conflicts. And often through that process, you would have these giveaways of great volumes of materials to seal or to ratify what had taken place in the big houses. And the missionaries and others who were relating to the Indians thought this was standing in the way of the Indian Act's message of assimilation and learning to become like Victorian citizens, because they felt this was profligate, right? Wasteful. Here you spend maybe years gathering all this material wealth, and at this feast structure you would then give it all away. And in giving it all away, this wasn't encouraging the kind of accumulation under the capitalist structures which were so important to that society. And so they were outlawed, these feasts, these and so you get legislation passed that makes it subject to fine or prison to participate in your government structures like that. And so some people are subject to the law, in quite harsh ways. There's, of course, the informality of the law, which also leans on the coastal nations quite strongly. And you get some instances where the Indian agent will come in and confiscate, or the priest will confiscate the masks that are used for the feast, and the button blankets, and the bent boxes, and the coppers, all of the treasures, it's like taking the mace out of Parliament and saying that's not the way you should govern yourself, and giving that mace to some interested collector who wants to enjoy the artistic artifact nature of that rather than the living nature of the instruments of government. And so these objects start finding their way into private collections across the country, and then they start finding their way to Washington and London and Paris and around the world. And so all of the symbols of government seem to be lost and displaced. So there's a real challenge there. What, though, happens is First Nations try to take their own way forward, and if they can, they use their own traditions to kind of subvert this structure. So, for instance, you might have the feast take place in the summertime, where all the business is transacted between the groups with the ceremonies, what's left of it. It might not always be done in the big house now, because that would attract too much of the attention of the missionaries, of the Indian agent. But nevertheless, you would have the affairs transacted. But then, in order with the giveaway, you would hold off until Christmas, right? And at that point, you would give gifts to others, and it would be very difficult to be able to prosecute someone for giving away something at that season, because they're encouraging, obviously, a celebration of Christian traditions. And so there was things that people tried to do to subvert the heavy hand of the law upon them. But nevertheless, it really forced underground many of these structures. At the same time, that kind of challenge was evident. The economic pursuits of many First Nations were being compromised. So in this part of the world, there was licensing of fisheries that began in the early 1870s, 1880s. And what the British Columbia government decided to do was to give licenses, and there were two types of licenses that could be issued. You could get an attached license or an unattached license. If you had an unattached license to be able to gather fish, you could sell that fish to whoever you wanted to in any place. You had sort of freedom of commerce, freedom of contract. If you had an attached license, if you caught a fish, you were only able to sell that fish to a qualified, registered government agent. So what happened in this setting is that unattached licenses were given to the so-called, in their words, whites, and the attached licenses were given to the Indians and to the Japanese. Now, if you have an attached license and you want to sell a fish to someone, you're at the mercy of that buyer. And if that buyer doesn't want to give you more than 5 cents a fish, it's too bad. You can't go out in competition then and try to sell that fish at 10 or 15 cents to someone else. And so what happens with both the Japanese and the Aboriginal fishery is that they start to become impoverished because of the monopoly in trade that they have to run the gauntlet through. They're not getting as much for their catch as the so-called whites, who maybe are doubling or tripling the amount that they're receiving into their coffers. That's, of course, bad enough on its own. But then when you put that over a few fishing seasons, and you want to continue to buy boats and gear and construct canneries, the native peoples are not able to capitalize. They're not able to accumulate capital in ways that allow them to buy the bigger vessels and allow them to become the proprietors of the cannery. And so what occurs is that Aboriginal peoples and Japanese peoples as well become the laborers in this system. They become the employees, not the owners. And so this system is basically if you don't follow the license system, your fishery is outlawed, or you're not allowed to fish without a license. And secondly, when you do follow the licensing system, you find that you're at a distinct disadvantage. And this way of pursuing commerce wasn't just something that was on the prairies. This also, on the coast, it also occurred on the prairies. There's a book called Lost Harvests by Sarah Carter, where she talks about the treaties, the number of treaties being signed with the chiefs picking out a lot of the best lands before settlers arrive for agricultural purposes. The treaties said that you have a right to bind or twine and farming implements like tractors and tools. And so what happens early on in the prairie context is the Indians become quite economically successful in agriculture. And then settlers start to arrive, and they arrive struggling, right? Putting up sod huts on prairies and the challenge of that narrative, which many of us know about. But they look at the Indians and they say, why are they getting Massey Ferguson tractors and twine to be able to bundle up the hay and the agricultural goods that they're pulling in? We get nothing. This is inequality. Not realizing that the 90% of the land that the people are unable to settle on is in compensation. They're getting the implements and the help with the farming is in compensation for that rest of the land being able to be used by others. So that wasn't always taken into account. And then, through a period of pressure, eventually the laws in the Indian Act are amended. And there's a policy that's generated by Indian Affairs. Hayter Reed is one of the superintendents of Indian Affairs. That's the peasant Indian policy, peasant Indian farmer policy. Indians were viewed as being lower on the scale of civilization. And so it's thought if you want to bring them up to the scale of civilization, they have to go through the same stages that Europeans went through. And so Europeans, once upon a time, scattered the seed on the land by hand, and had to use rudimentary implements, not machinery, to be able to pursue agriculture. And so farm implements were no longer given, like tractors. The people were sent out from Ottawa and other places to basically have to sow that prairie land in a different fashion than been used to. Now, if you've been using a tractor for 10 years and suddenly have to use a hoe, you'd probably be discouraged, and you might not put as much land in production. And what happened then after that policy was implemented for a few years is there was much less Indian land in production. Next wave of settlers come along and say, look at these wasteful lands here. They're not being used to the highest and best purposes. Maybe we should move these Indians to a place where they can hunt and fish and just follow their own traditional lifestyle, not recognizing that it was the government's own engineering that was making agricultural harvests less productive. So with that pressure, you get what's called a prelude to surrender. Indians are moved away from those richer agricultural lands, moved to some of the areas that are much more marginal in terms of farming capacity, places that are quite dry, etc. And then wouldn't you know it, after that happens, the railway goes through. And the railway, which allows the development of the prairies, now skirts by all of these growing settler communities, and the Indians are marginalized and away from the lines of commerce. And so you find through that process, like in British Columbia, Aboriginal peoples not being able to get that capital accumulation, and even though they had been successful as fishers for thousands of years, successful as farmers, not only when the traders came, but before. Now the bigger challenge is present. At this moment, you also get residential schools that come into the equation because it's the explicit policy of the government to take the to kill the Indian by killing the culture of the Indian. And the best way to do that, they thought, was to take the children out of the community. If you couldn't pass on the traditions, like we were talking about with the Haudenosaunee or the big house, you would just put them in schools. And so through those years, you had about 150,000 children go through these schools just in kind of violation of their ability to be able to be in their family units. And in some instances, residential schools were helpful to Indians in that there are some small places where people felt like they got the benefit of that education, or there was things that were challenging at home, and they were able to enjoy a better standard of life. But that's the exception, not the rule. There's the Truth and Reconciliation Commission report on Indian residential schools that came out this past June, and you read about all sorts of abuses there. Dan?
Yeah, sorry to interrupt. I'm really curious about you talking about beneficial or benefits of the residential schools. Can you provide another example?
So I had a friend when I first started teaching in law school. His name's Alfred Scow. He grew up on the central coast, the Muskama Zawadeno people. He's a Quagio person.
And
Quagio. It's on the central coast of British Columbia, the north coast, north of Vancouver Island. And he was a fisher by trade, but he went to residential school. And through residential school, he was able to get a grade 12 education. And with that, eventually was able to go to university. He went to the University of British Columbia. He eventually graduated with a law degree. He became the first lawyer who was Aboriginal in the province of British Columbia. Another thing that happened at residential schools is that it allowed people from different parts of British Columbia who were native to communicate with one another. So Frank Calder, who we'll read about as a part of the Niska case, the Calder case, when we deal with Aboriginal title, would interact with Frank Paul, who is a Squamish person. When they were young people, they were just friends and playful with one another. But when they grew and went back home from residential school to their own communities, they had long-distance relationships. And they were able to strategize politically and develop webs of connection across the province for future advocacy purposes. So, 2 points. Some people got the benefit of education, and there was a greater knitting together of Aboriginal peoples across the province and across the country in their different regions as they attended those same schools. That helped them in eventually the 1960s and 70s and 80s when you try to move beyond some of the things that we're talking about here in this era. But I want to make the point that's the exception. It's not generally what occurred. But I also don't want to skate that over. It's important to recognize the complexity of history and the complexity of people's experience. Just like with the potlatch, where people try to take what's happening to them and as much as possible turn it to their own advantage, so it happens with residential school. People are not just passive victims in the stream of history. Right? People find ways to use their agency. They find ways to persevere in the face of great disappointment and harm and abuse. And now we need to stress the abuse that took place in these schools. When these kids would arrive, they would be often dressed up by their parents in their best garb. Sometimes it was traditional ceremonial regalia, and they would be taken by the people that ran the schools, and they would be clothed in itchy wool, uniform-like structures, clothing. They would be doused with lye. It was just stripped, clothes taken, doused, hair cut. And then if you speak your language, you would be punished. It was a place to make sure that you didn't continue that. So the kids at the Port Alberni Residential School here on the island had needles stuck through their tongue if they spoke their language. Right? Kids would be constantly being corporally punished, slapped across the wrists, across the knuckles if they spoke their language. And this kind of abuse at a cultural level obviously causes you great trauma about who you are as a person, thinking, should I be an Indian? Should I be Salish? Should I be Haida? Should I be Ojibwe? It seems like that is regarded as being savage, pagan, retrograde. And so you come through this residential school structure really questioning how you are to be in the world. You also don't get the parental love. You know, you're in an institution, and the institutions don't have well-resourced, they don't have good resources, so you eat mush every morning. And the things that you produce in the garden is what you eat. And so, you know, when, as the end of, you might have some produce in September, October, but come February, March, you might be eating potatoes every day. So there's a great physical challenge there. And imagine being a parent in that setting. You get your little kids ready to send off to school, and then you can't see them for 8 or 12 years. Right? And you've prepared them so nicely. And sometimes you don't want to send them, and you hide your kids, because you heard from other people that have come back that that's a really evil place, right? Not to put, that's not overbroad. It's an evil place for us. And so kids hide. But the Indian agent still comes and scoops them up, and you're taken away kicking and screaming to go to that school. And the parents' anguish that's left by not having your children in that setting is quite obviously profound. And this goes on from generation to generation, right, for over 100 years. And people start to feel a sense of disorientation. But not everyone, right? We need to remember the agency of people and the resilience of people. That I told you last class, one of my good friends, an elder, Basil Johnson, passed away last week. He wrote a book called Indian School Days that you can read about his experiences at Spanish residential school, Spanish Ontario, Espanola area. When they had to peel the potatoes, they divided themselves into hockey teams. One was the Toronto Maple Leafs, the other was the Chicago Blackhawks, and they made a competition out of it. And they would pull pranks on the teachers and one another. You know, they did what they could, but there was sexual abuse. There was people were going through so much. Just as I walk through life, most every person I know that's maybe 10 years older than me has either gone to residential school or had some kind of really negative experience with their family member, brother, sister, aunt, uncle in that setting. My own family is affected by it. My mother ran away from the reserve at age 14 to get away from the potential of going to residential school because she heard how terrible it was. So she ends up in Tillsonburg, Ontario, as a 14-year-old picking tobacco out of the fields, and just living on her own or with her sister by and large. And likewise, fleeing from the schools. People would run away from these schools, and they would often die on those journeys. There's so many people that died in residential schools or died trying to get away from residential. And then my mother carries the guilt of, because she ran away from home, she thinks her younger 18-month-old twin brother and sister were taken away to residential school. Of course that's not her fault, but she sometimes thinks, if I would have stayed there, I would have maybe helped out with the family a little bit more, maybe they wouldn't have had to have gone to that setting. So much that sets in when residential schools are in that fabric. I didn't mean to go on to that length, but I'm just trying to respond to the question in a way that nuances this. I want you to see a complex picture here, but I also want you to see within that complex picture the negative side that it really does end up shading down into. So you put that against another piece of legislation in the 1910s and 20s. The chiefs here in British Columbia were really like the Haudenosaunee organizing to say this is unacceptable. What the Indian Act is doing, what's happening economically, what's happening spiritually, what's happening with our children, we want to change it. And so they get ready to go to the Privy Council, the executive in this case, in England, to make a complaint. And things are lining up for them. It seems as though Ottawa, for a little while, is a little bit supportive. The province is never supportive, but it sort of is starting to recognize some of the writing on the wall. But then a change in government occurs in Ottawa, and you get an amendment to the Indian Act that makes it illegal to be able to consult lawyers for the purposes of land claims purposes, makes it illegal to be able to meet in council, to be able to discuss these things, so people could be fined, they could be imprisoned if land claims was a part of their advocacy. And this provision suddenly stops so much of the political momentum and energy that was gathering in this province. So imagine you're a community in the 1920s in British Columbia. You want to change something. Well, you could go to your traditional governance, but that's being targeted. You could go to Parliament or the legislature, but you don't have a voice at the ballot box. You could maybe take solace in your family life, but that's being torn apart. You might think, well, maybe I can just at least take some solace in the spirituality of the world. That's being attacked. And now you actually even have the courts cut off from you as an agent of accountability. And sometimes people wonder, why are we still dealing with these issues in this age? Because in 1951, that was the date that this was removed.
How publicly widespread were those types of amendments? I know news wasn't what it is now. If an amendment happens in Parliament, we'll know.
Yes.
But my guess is that an amendment to the Indian Act would be, not given a second look.
Yes.
In Canadian society. So was there
So for the most part, Canadian society was very supportive of this trajectory that I've been talking about, because they thought that Indians were not well served by living in their families in a reserve type setting, that it was getting in the way of their advancement as peoples, and so there was a great, by and large, support of this. And a lot of that support was also coupled with what was going on in the congregations and churches across the country. This was the reformers of the era. They weren't necessarily setting out in their mind to think that they were doing something wrong. These might be people like me or you who think in the world, reform, people on, this is what the path would be. Of course, in the First Nations, it was a different story. You saw what the Six Nations said when the Indian Act came out. All of these embassies and groups were going to Ottawa and Victoria and just being rebuffed. So the Indians knew what was going on and didn't like it, and Canadians knew what was going on and thought, yeah, this is the path forward. Yes?
Yeah, this was the era of eugenics, right?
There was the eugenics movement that started to take place in the 1930s, and in fact there were experiments that were done. One's called the Files Hill Colony in Saskatchewan, where they tried to engineer families, choose who would be the best to be able to mate with one another, and get the strongest man with the, you can just imagine what that would look like. And that was a part of it. Women in the 1950s and 60s were sterilized, Aboriginal women, because the best way to deal with this is just to make sure that there's not another generation. Now that sterilization was not in the hundreds and hundreds, but it was in the tens and hundreds, right? It was a significant enough, and for the person that's sterilized, of course, that is enough just of its own to make it outrageous. So that's a good question. So you're trying to deal with this stuff in your life, and there seems like there's just so much difficulty in dealing with it. And then all these treaties that have been made, which were so honorable, right? The peace and the friendship and respect and using Indigenous tradition, etc., they start to fall by the wayside, and you maybe don't get the twine anymore, or the fishing nets, or maybe you get the $5 payment, but in some of the treaties, people said, well, there was an escalator clause, like the Robinson-Huron Treaty on the North Shore of Lake Huron, which is, as mining continues, they would continue to draw the revenue from the mining, not just the $5 a year. Add to that, we've already talked about the explicit assimilation policies Duncan Campbell Scott said, our object is to continue until there's no Indian problem, because there's going to be no more Indians in Canada. And the way you have no more Indians is by assimilating them. The Métis people encountered similar kinds of challenges. Through their treaties, they were promised scrip, which was a document that you could take that would allow for an area to be registered, like a 240 parcel of land, for instance. And that we'll talk about this when we get to Métis issues. The script was not administered in a way that was fair, and the Supreme Court of Canada has also said there's a violation of the government's fiduciary duty in the way they dealt with Métis. When tribes, First Nations, try to object to this, sometimes those that were most vocal would be cut off the membership rolls. Right? If you were challenging this, you were no longer Indian. Maybe you had education, you were enfranchised, meaning if you got a university education, you couldn't live on that reserve anymore. You couldn't participate in the politics of the reserve anymore. And then in some cases, then that becomes an excuse for further reducing the size of the reserve. So a lot of the interior reserves in the Okanagan were cut off, and people lost, rich lakefront properties, Kelowna and Kamloops and etc. That happened, here in Victoria and Vancouver. And so not only was Aboriginal title not recognized, but the little patches, postage stamps that were given as reserves were also further eroded in that period. Women in the communities were also targeted because one of the ways you pass on culture is obviously by having healthy relationships between men and women. If an Indian woman married a non-Indian man, she would lose her status. She would lose her, and in losing your status, you no longer have a right to live on the reserve. That's what the Indian Act says. And in losing your status, you no longer have a right to be able to participate in the politics of the reserve. So there's all this intermarriage that occurs, and all of these Indian women are cut off from membership as a result.
I just wanted to add that non-Indian women marrying Indian men actually gained
That's right.
status.
And so on the flip side, if you were a non-Indian woman and you married an Indian man, you would get status. And so you start to change the structures of the community in that regard. And we're going to have a couple of sessions where we focus on the cases around that, the legislation around that in more particular terms. But remember a moment ago I talked about the clan mothers? Right? If all the clan mothers are leaving the community, what does that do to your traditional governance? In the two world wars, Indians went off to fight in great numbers. You go to Cape Croker, like 90, my reserve, but 90% of the eligible people signed up. A lot of communities did that. And the ones that came home often came home with post-traumatic stress syndrome, etc. But if you're a veteran and non-native, you could come home and you could apply to the Department of Indian Affairs. You could get some land allotted to you, or you could get some educational benefits. If you were an Indian and you came home, you don't need land, you've got a reserve. You don't need education, we've already got this other system set up for you, residential school. So the people who had gone to fight against great inequality and racism and discrimination, it gave their lives as allies of the Crown to do that, and they came back and faced this further indignity, which is still working. Most of these people are now gone, but it never was really resolved to the satisfaction. The Inuit people, this same era, are being relocated all over the place to try to advance American and Canadian sovereignty. This is during the Cold War now, right? You're worried about the Russians coming across the ice caps or sending missiles or planes across the ice caps. And you want to show you have sovereignty in the Arctic. So what they did is they take people from the Ngaba Peninsula and north of Quebec, and they send them 1,000 miles away to Ellesmere Island. They don't know how to live in that environment. But they're Eskimos, right? They must know, they're northern people, they must know how to do that. But of course the fish and the game and the weather patterns are totally different. And there's so much despair and harm and hurt that occurs as a result of those relocations. There were the amendments to the Indian Act of 1951, which did some limited things. It did allow, again, Indians to be able to finally talk to lawyers and talk with one another about land claims issues. But of course, in 1951, that's hard to do. It's actually in the 1970s, after these amendments are removed, that you start to see things coming out. And in this period, as now people are leaving residential schools and fleeing the reserves, you start to get this period of over-incarceration. Up until the 1970s, the number of Indians in prison were roughly proportional to their percentage in the population. But now you go to a place like Saskatchewan or Manitoba, and you find 70, 80%, in Saskatchewan particularly, of the people in prison are Aboriginal people. 23% of Saskatchewan, I think, is Aboriginal. 80% of the people in the provincial facilities are Aboriginal. And so you get another round of institutionalization. Yes?
I'm just wondering if, and like, has there been anything looking into what changed in that period to make that start with the over-incarceration?
I think that things, you get an urbanization that starts to occur in the 1960s, more generally as Canadians, but also for Aboriginal peoples. And so you get people's leaving the reserve, but they're coming out of residential school often with little of the same kind of skills, because the residential school education that was received, you might graduate from grade 12, but it's equivalent to grade 5 education. So you're not always in that competitive place.
I want to say about the residential school. Often our children were put in kindergarten or grade 1, and they never left until grade 10, and so they didn't know how to live as part of a family or outside of an institution. So that may have been part of what put people in jail.
That's right. So that you don't have the skills in terms of the qualifications that other people that are graduating in grade 12 have. You don't have the family structure and support that other people might have. Imagine the poverty that just is endemic to going through this experience, and sometimes that has led to that situation. And then finally, in this era, as residential schools start to shut down, you get a rise of a professional class of social workers, and there is this challenge on reserves, and you start to get kids taken into care in non-Aboriginal homes. And again, what you get in, like in British Columbia right now, 50% of the kids in care are Aboriginal kids. And maybe they're about 11% of the child population. In Manitoba and Saskatchewan, again, you're way up into the 60s, 70s, 80% of kids in care being Aboriginal kids. So the picture we painted last class of reciprocity and linking arms together and intermingling values, a morally and politically dispensable conception of Aboriginal rights incorporates both legal perspectives. You see the erosion of that quite strongly. But I need to say at this moment, this needs to be recognized eyes wide open for what it is. But people are resilient. I'm going to say this again. People are not just passive victims. People do what they can. They're not always able to do it. But people do what they can to be able to make their life better, even in these circumstances. So, you grew up on these. My mom grew up, born in 1937, went through a lot of this stuff. She is a beautiful, happy, accomplished person that is traumatized by this, but lives in a way that tries to create happiness and goodness in other people's lives. And I, again, this weekend when we were home with the elders with this Anishinaabe law camp, there's laughter, there's humor, there's goodness. It's not a complete downer. We love our reserves. They're beautiful places. They are still a nest, a home, a place of strength. They are also challenging and rife with tension, and as other communities are, but there's this extra layer that's a part of that. So this is the changes that people start to see as a result of the departure from that Conley and Woolrich vision or the vision set out in the Siwi case, or the Chippewa of the Sarnia case. This isn't the wampum belt analogy that we saw earlier. But people did their things to remain. So for my great-grandfather was a hereditary leader. Then he became an elected leader under the Indian Act for 50 years. In other words, people tried to strategize and try to adopt. Yes, you're dissuaded from having this hereditary form of government, but it's still possible to be able to think about advancing interests even in elected forms. So now we come to this Logan and Stiers case. Here's the council from the 1920s in the Mohawk and the Six Nations Confederacy. This case, as you know, was brought by the clan mothers. The clan mothers were objecting to the chief and council taking a surrender of 3.5 acres of land in their treaty territory along the Grand River. The clan mothers said that the band council, the elected governance system set up by Parliament, doesn't have the authority to surrender the land that we have reserved to us under agreement, under deed, under treaty. And they say that what the elected council is doing is ultra vires. It's beyond the scope of authority of the federal government to be able to set up a band council and through that puppet form of government further diminish land-based, further diminish governance traditions. And so the clan mothers bring this issue before the court in Ontario in 1959. And it's in the materials. We read the case for today. And so the question is the band council's action that was then affirmed by an order in council by the executive, is that ultra vires? And the court says it's not ultra vires. It's within the authority of Canada to be able to set up Indian Act governments and ignore, and do more than ignore, overturn traditional systems of government. So you read in the story, right, that these people had their wampum confiscated from them, which is what they used earlier I talked about. That's how they read their constitution. So the constitution is confiscated. One day they come to their council and they find their longhouse boarded up and the RCMP standing on guard to prevent you from coming into council and making your decisions. And they object to this, right? They object to it in the United Nations. Right? They object to it in the League of Nations. They try to make their case known to the world community. But the Ontario court says, you have all these documents, and they go and they talk about the Haldeman deed on page 40 of the materials. They talk about the Simcoe deed on page 40 and 41 of the materials, which guarantees in perpetuity to the Six Nations their lands, their governance. Right? This guarantee in perpetuity forever, the court reads that and says, well, that can be overridden by the fact that when you receive the protection of the crown, you then owed allegiance to the crown and thus became subjects of the crown. So that's linking arms together is read by the court as subordination to the federal government, as opposed to an ally of the federal government. And so that's the ratio, that's the reason for the decision here, that the bylaw and the order in council can stand. Now, we should note that only about 70 or so people voted in the election, and only like two-thirds voted in favor of the surrender. So you maybe have, I don't know at the time, maybe you have 4,000 people living at Six Nations, 70 people vote. I forget the right number, but maybe 40 people say yes, we allow this to be surrendered. 40 people get to make the decision for 4,000 people because somehow the elected government is considered to be legitimate. Well, of course it's not within the community. And the Six Nations still struggle through this. There's a note in the materials about Caledonia and the dispute with developers in Hamilton that began in 1995, still not settled. The idea that they have is that those lands that are being occupied by other people through development are given to settlers by an illegitimate government. There was never any authority in that government to do that thing, but the court, in Canadian law's eyes, said no, that is the legitimate authority. And it's still the case that most Six Nations people do not vote in their band council elections. It's a very fraught system, and it shows that attack on government. I wish we had time to talk more about the speech of Githskahi.
The receiving protection of the crown, did that come, was that an interpretation of the text of the treaty?
It's an implication that's drawn, but it's not actually, when you look at the Haldeman deed and the Simcoe deed, the kind of words that they use are His Majesty's faithful allies, and by their bravery and conduct, we, desirous of showing our approbation of the same, and in recompense of the losses they may have sustained, we provide this tract for them. Right? In other words, it's not the wording of the treaty to say you are subject to the crown. It's saying you're allies, but the implication that the court draws is, well, that must mean subjugation by receiving this protection. So that obviously weighs heavily upon the people. We talked about Githskahi. You can read the materials. It's a moving speech. And Haudenosaunee people continue to travel on their passports, and were only recently denied. But they would go to international events before 9/11 and were able to take that course of proceeding. Right? A nation-to-nation relationship. So there's other material in the Indian Act, in the materials that talk about the Indian Act and its problems. Basically, power flows one way from the federal government to the chief and council to the community. It's not a grassroots way of thinking about government. There are criticisms of the Auditor General that are in the materials. There's a lack of clarity in service levels. We'll talk about this a lot. Indians don't get the same education dollars, the same healthcare dollars, the same child welfare dollars, the same water improvement system dollars. Right? So you get boiled water advisories and higher rates of diabetes and kids that don't finish school and very difficult issues dealing with children. There's a lack of accountability that the federal government has to Indians. It's often the case is put the other way. Indians aren't being accountable. Let's make it more transparent. But everything is done through policy by Ottawa. And if they don't follow their policy, you can't challenge that. It's a policy. Right? There's no obligation that Parliament has created for itself to be able to follow a path of service delivery. There's a lack of an appropriate funding mechanism. Often funding is given just year to year to year. So if you want to create a 5-year plan to develop something in health or education or children's services or water, etc., you just can never count on that being there. Whoops. And again, there's not a bureaucracy on the ground that helps to facilitate that service delivery. This is the recent report of the Auditor General. There's a bit of an Indian Act's content and structure that is reproduced in the materials under, you can see the Powers of Council in the materials under Section 91. But it's interesting, the powers that are given. It's often like beekeeping and dog catching and making sure that fowl don't run loose on the reserve. Not the stuff of day-to-day life that's necessary to sustain a healthy community. There's this recent First Nations Financial Transparency Act. This act is trying to provide some accountability, and there are some outrageous figures in terms of chiefs receiving money. But if you actually look through the list, It doesn't usually come to this level, pretty run-of-the-mill for the most course. And of course, there's more than just running the First Nation here. Many of these communities that you see here have private investors, and they have to report their private investments now to the government, which is chilling private investors. Like, why should I have to say what I'm, doing in this partnership?
Oh, I was just gonna ask about the inclusion of other funding streams that have nothing to do with
Yes.
the federal government.
This includes other funding streams that have nothing to do with the federal government as well. Often these chiefs and council have to maintain different portfolios. So there's the Pamajuan case in the materials, which is the last point for today, which is the attempt to use section 35(1) to deal with Aboriginal government. In this case, the Shawanaga and Eagle Lake Reservation said we have a right under section 35(1) to govern our community. Part of the governance of our community is to provide economic development. The way we want to do economic development is through high-stakes gambling, and that's been quite successful in the United States. $25 billion business for tribes in the United States, and they've diversified their portfolio beyond that. Then they reinvest that $25 billion into other types of revenue streams. In Canada, in Pamajuan, the court said you can only have a right to govern something if the activity that you were engaged in was integral to your distinctive culture prior to the arrival of Europeans. The court looks at gambling and says, yes, you guys gambled, but you didn't gamble on a 20th century scale. It wasn't integral to your distinctive culture. And therefore, since you didn't approach gambling in that way, you cannot claim a right to govern gambling in the present situation under section 35(1). The court also said in this case, basically, that you cannot construe governance at a broad level of generality. There's no such thing right now under section 35 as a broad inherent right to self-government. You'd have to show that the activity that you're wanting to manage was integral to your culture prior to the arrival of Europeans, which allows for the introduction of all sorts of stereotypes about what was integral to their culture. And we're going to talk about this when we come to the Sparrow and the Vanderpeek cases later on. The Dalgamut case held the same thing. You can't construe governance at a broad level of generality. We're through for today. We're going to pick this up, though. Maybe we'll pick it up. We will pick it up with the NISCA agreement. But I'd like you to reflect on this. Any questions you have or comments about that, pick this up in the next class. So, see you Wednesday.